all we say to America is to be true to what you said on paper. And we have come here to dramatize a shameful condition.
Mere allegations. Mere allegations is a hair trigger requirement to enforce at least one provision of the Voting Rights Act of 1965, which had been urged by Democrat President Lyndon B. Johnson to members of Congress in a famous speech on March 15, 1965. A long time ago, but not so long ago for some of us. The Voting Rights Bill was passed with a 77-19 vote in the Senate on May 26, 1965. Very quick time. And finally passed by the House of Representatives after some heated debate on a 333-85 vote on July 9, 1965. And it was not until August 6, 1965, while I was still being conceived and in the womb, that President Johnson had signed the Voting Rights Act into law with Reverend Martin Luther King Jr., a friend of my father, who was not a voting rights activist like Medgar Evers, the franchise martyr, or later Reverend Jesse Jackson, the presidential candidate, and other civil rights leaders present at the historic signing ceremony. And it had aimed to overcome legal barriers at state and local levels that had prevented African Americans from exercising their right to vote as guaranteed under the 15th Amendment. So if there's nothing else that you now know, the 15th Amendment is where that comes from. And after a pandemic, when many broke records, performing what they had described, at least, as their duty, while politicians on both sides of the aisle were committed to ensuring that the elections must go on because democracy was at stake, most should be at least a little familiar with the Voting Rights Act, even if not its individual provisions, because it has featured so prominently, especially in political contests in the South, amidst cries of voter suppression, often involving identification at polling places. But many may not be intimately familiar with the particular provisions of this law that contain this provision upon which just mere allegations of violations of the 14th and 15th Amendment can bring down the power of the federal government to ensure that the franchise rights of persons of color are neither violated nor abridged. And the more you know about politics and laws and their provisions, the more informed you are as a voter. So that someone can't just say, I'm for voting rights, and pull the wool over your eyes. And in politics, we often say that if you are ever invited to a poker game and don't know who the sucker is, it's probably you. Hello, my name is Major Mike Webb, and in an identity politics, I have been assured that I ain't really black. But I can say that even the president has described me as passionate. Merrick Garland has described me as a litigation hobbyist. And not many people can say that. Like the president, I grew up in black church, but my father was not only a black man, but also a pastor of a black Protestant denomination church. Just like his father, who had not only built a church that today, over a century later, stands on the National Historic Registry, but he also has the distinction of being a franchise martyr. And not many people can say that their grandfather took a bullet for the right to vote. I can. My godfather, who had been my father's son in the ministry, but by the grace of God, I also thought that it was such a big deal when he got elected to Congress that by that December 1978, as I well recall, when we had gone to Philadelphia to worship with him in his church, Bright Hope Baptist Church on Broad Street, across from Temple University in Philadelphia, he had already purchased a vinyl congressional seal to place on his Samsonite briefcase to carry his important papers, let everyone know that he was a congressman. And when you can get elected by a popular vote, it stands to reason, and in your best interest, that the right to vote becomes a rather important thing. And today, at least according to the president, if you didn't place your vote for him, that mere allegation is sufficient to declare that regardless of whatever it says on your birth certificate, or the color of your parents, or what your friends will say you were in high school, then because of that vote, you ain't really black. A hair trigger effect activated by your choice in an election. And some say that it is what it is, which is a defeatist attitude to which I rarely ascribe. And that provides the setting for a present case in federal courts in which this hair trigger provision under the Voting Rights Act of 1965 and mere allegations have central prominence. And if you are sincerely interested in the franchise right, the next few minutes I shall attempt to provide some background on this litigation. Actually, now two litigations, one in the district court and one now on appeal, and the other a separate act in mandamus at the Court of Appeals, and how this provision of the Voting Rights Act, prominent progressive Arlington Democrats are now preparing to defend against in court. And as they say, politics makes for strange bedfellows. And in politics, where you sit is very often where you stand. So let us dig into the material, as they often say in law school, at least Tier 1 law schools. I don't know which one your attorney may have gone to. The controlling law or relevant provision had been codified at 52 United States Code or USC section 10302, paragraph capital A, which expressly provides, I mean, very, explicitly, these are the words, nothing more, nothing less, that whenever, what does that say to you? Whenever, that means anytime, an aggrieved person institutes, got some big words here, so I'm going to read it slowly, a proceeding under any statute to enforce the voting guarantees of the 14th or 15th Amendment in any state or political subdivision, the court shall, with few exceptions, authorize the appointment of federal observers by the Director of the Office of Personnel Management or OPM. Too easy. And in law schools where students are taught canons of statutory construction, or how to read the legalese in these complex laws for which we elect people in Congress and legislature, we have some very important words in just this short sentence. And for the elements required to establish what is often called or described as a prima facie case, Latin word, to add to your vocabulary, we need first an aggrieved person, or someone who believes, at least, that they have been actually and directly injured. Not just complaining on social media, but direct action reasonably calculated to effectively, not just efficaciously, provide a remedy, therefore, as long as the allegations arise under the 14th or 15th Amendment. Mere allegations. You don't have to have a court issue an order to say that you prevailed. Just the mere allegations, accusations, if it were. Then, upon application of this formula, this formulaic expression, like 1 + 1 = 2, always, the court must, therefore, contact the folks at OPM and have them issue a federal job announcement for persons to be hired as seasonal employees to serve as election observers. You can go off and, brag to your friends you were an election observer, taking part in history, or just getting paid during the extended now voting period. Does that sound complicated at all? It shouldn't. But apparently, even after 1 month, the federal court in the District of Columbia thought about it and finally, after a month, said that it didn't understand that provision of the Civil Rights Act. And then went further to dismiss the complaint, prompting an action brought on appeal. Basically, we are going to somebody's supervisor to raise the original complaint just a little bit higher. and shall take this matter all the way to the Supreme Court, if or as necessary. And if the Arlington Democrats prevail, then you can thank them for rolling back your protections for your right to vote. And the reason why they are probably against this law now is because your right to vote is only important when you loyally and religiously cast your vote for them. Self-interest, which in reality is not a very democratic thought at all. And you look like an intelligent person. Particularly for unrepresented litigants, the Supreme Court, the highest court in the land, has laid down some bright line rules to protect the civil rights of unrepresented litigants, or pro se litigants, as they say in Latin term. And it is now established that pleadings should not be scrutinized with such technical nicety that a meritorious claim should be defeated, such that especially a pro se complaint should not be dismissed summarily unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. This dovetails on a basic rule in terms of pleadings and complaints that to survive a motion to dismiss, the complaint must have at least facial plausibility, but all allegations are generally accepted as true at the preliminary stages before an actual trial to attempt to prevail on merits. But the trial court in this case decided that it could not discern any cognizable claim after 1 month of examining the complaint. Imagine telling a police officer that you can't read, and the officer being able to tell you, with full protection of the law, he doesn't understand you. That would be this case. And if you agree, then you have the opportunity to vote for the same in November. But as for me and my house, we shall follow the law. Can I get an amen? Moving on. In statutory construction, a topic with which you would become rather intimately familiar had you attended a formal law school, at least a Tier 1 law school, to enable you to think like a lawyer, as they say. Engage in zealous advocacy for your client, even if that client be yourself. You would then be aware that there are rather immutable rules, unchangeable rules, dictating how a provision may be interpreted, and generally in what is referred to as legislative deference. The rule is that had the legislature intended any other purpose or meaning, it would have said so. Too easy. If it's not in the contract, you can't do it. Further, a statute should be read to give reasonable effect to the word used and to promote the ability of the enactment to remedy the mischief at which it is directed, which does not provide a lot of wiggle room. When you go beyond that, then that's what we call abuse of discretion, or a finding of fact could be clearly erroneous. Moreover, where a particular construction of a statute will result in an absurdity, some other reasonable construction which will not produce the absurdity will be found. Zero tolerance for absurd results, unless, of course, you wish to vote for an absurd result. Nonetheless, in this provision of the Voting Rights Act, a court is presented some leeway, and a court can ignore this rather extraordinary hair-trigger remedy in only 3 instances under the controlling law, which provides the following affirmative defenses, as we say. The violations have been few in number and conjunction, very important conjunction, have been promptly and effectively corrected by state or local action. If they are still going on, not going to happen. 2, the continuing effect of such incidents has been eliminated. If this is still going on, court cannot just ignore this law. And 3, there is no reasonable probability of their recurrence in the future. This may happen again. The court has to contact OPM and have them select election observers. However, in the court order dated May 19th, in the matter Webb v. Lopez, the trial court circumvented this criteria and rather had relied upon a provision of the Federal Rules of Civil Procedure, Rule 8, erecting what we call a prudential rule of standing, which defines the proper forms of pleadings before court. And sitting alone in a Birmingham jail, Reverend King, a friend of my father, writing long letters, singing strange songs, and praying long prayers, had written words to history. Sometimes a law is just on its face and unjust in its application. For instance, I have been arrested on a charge of parading without a permit. Now, there is nothing wrong in having an ordinance which requires a permit for parade, but such an ordinance becomes unjust when it is used to maintain segregation and to deny citizens the First Amendment privilege of peaceful assembly and protest. And this is a rather well-developed exposition regarding what attorneys and legal practitioners would describe as an as-applied challenge to a law, as compared to what is described in legalese as a facial challenge, which attempts to invalidate an entire statute or statutory provision. The most difficult challenge, then, because there can be absolutely no circumstances under which that law would be valid. One exception, you lose. And currently on appeal, we are developing such an as-applied challenge, which should be a lot of fun. However, working on our side is another precedent articulated in the case Reed v. MSPB, which provides protections to persons against whom retaliation has been directed. And if you feel that you've been retaliated, maybe you need to listen, most often in the workplace, which the Arlington Democrats, even though they're pro-union, are free to assail and roll back. Reed v. MSPB articulates what has been called a timing knowledge test to determine whether conduct is retaliatory. And the complainant need only demonstrate that the deciding official or judge knew of the protected activities, such as presenting a case to court, and that the adverse action was initiated within a reasonable time of the same. Reasonable time, adverse action. This is described by attorneys as a burden-shifting mechanism, shifting the burden of proof to the other side. I don't have to prove it. You have to prove it. And in the present instance, a complaint had been filed on April 21st. Timeline is important, but about which the court took no action. For whatever reason, ignoring the Voting Rights Act that had mandated the appointment of these election observers. And on May 15th, a motion was filed to kindly remind the court about the requirements under the Voting Rights Act, that just mere allegations should have triggered some action, which indeed it eventually did after the motion, because even though they had not occurred before that motion on May 19th, the court decided to dismiss the case entirely, with just 1 month remaining to qualify for the November ballot. Under the timing knowledge test, a complainant need not demonstrate the existence of a retaliatory motive. You don't have to go in there with proof. I can prove that you were retaliating, to establish that the protected activity was a contributing factor. And moreover, this works for those people that are trying to do this. Once the knowledge timing test has been met, an administrative judge must find that the appellant has shown that the protected activity was a contributing factor. You win. Even if, after a complete analysis of all of the evidence, a reasonable fact finder could not conclude that the appellant's protected activity was a contributing factor. You have that on your side. Now the game has changed. You're in a more favorable position. However, if the Arlington Democrats wish to challenge this and prevail, you have them to thank for eliminating this provision of law for you and protecting you if you're ever in a retaliatory situation, and can express your thanks in November to them in the November elections. Your party and your choice. And this, in a nutshell, is the case presently before the federal judiciary in two matters. One, brought on appeal of the dismissal, and two, a petition for writ of mandamus that was sent up to the Court of Appeals to basically tell that court that they had to appoint these election observers, at least. And the only reason why they chose to do this is, of course, political. But this is a matter in which not even the NAACP or the ACLU have expressed any interest. And the only reason why it appears is because if you ain't really black and don't vote for bad candidates, your black life really doesn't matter. And if you don't know, and as Reverend Kurt Franklin says, now you know. My name is Major Mike Brett, and I am running for state legislature in the 3rd House District of Virginia. And I earned my majority in the U.S. Army. This briefing is unclassified. Honest. Carry on.
Start talking as the men start moving, and they all start fighting.
And we have come here to dramatize a shameful condition.
Nothing's the answer, my friend.
This message was approved by Major Mike Webb. Honest.